In week 2 of Karen Reed's second trial, there have been some explosive moments. We're going to tell you all about those and a whole lot more on this episode of Charlie Crime Buster. It is what some people are calling the fastest minutes in podcasting.
The views and opinions expressed in this presentation are solely those of the individuals participating and do not represent those of city, county, state, or federal law enforcement agencies nor sponsors and platforms of this presentation. All individuals described or mentioned in this presentation should be considered innocent until found guilty in a court of law. This presentation contains subject matter such as violence and graphic descriptions. Listener and viewer discretion is advised.
Well, hello and welcome to another episode of Charlie Crime Buster. We're right there on the Karen Reed trial, the second trial. And boy, has it not disappointed. We got a lot to share with you today. Glad to have you on board the old Charlie Crime train. But first, let's do a little housekeeping. You know, it humbles us that there are thousands of downloads on our episodes, and we're very grateful for that. We'd like to invite you to reach out with a shout-out. You can reach me, charliecrimebuster at gmail.com. charliecrimebuster at gmail.com. You can ask questions, make suggestions about other episodes. You can even lodge objections and disagree with our commentary. In fact, we welcome it. It is a safe zone. That's charliecrimebuster at gmail.com. If you'd like to support the program, go on over there and read about our sponsor, peacemakernetwork.com. This month of May will be Law Enforcement Appreciation Week coming up, and we would encourage you to take a moment to read about those brave first responders. We're talking about law enforcement and other first responders, and Peacemaker Network is also talking along the lines of our brave men and women of the military. You can read all about that at peacemakernetwork.com. You can even become a part of the program by being a badge, BADGE supporter. peacemakernetwork.com. If you'd like to get caught up on other episodes, you can do it one or two ways. You can go to our own website, charliecrimebuster.com, or you can go to our YouTube channel. We have there placed our episodes, easily for you to find and easily for you to get caught up. We'd encourage you to go to either of those places. And you know what else? We're going to make it very easy for you. We're going to put links in our show notes on those that I've already mentioned. So all you have to do is just reach over there and click, and you're already there. Hey, thank you again for joining us on board the Charlie Crime Train today as we talk about Karen Reed's second trial. Well, my friend, week 2 of Karen Reed's second trial certainly did not disappoint crime junkies for sure. There may have been people who were thinking, well, that they might get bored regarding hearing the same things over and over again, right? Well, they are probably wrong. There have been some explosive moments in week 2 of the trial, and yet we still have a long way to go. So today's podcast, we're going to get you up to date with week 2 of the trial. Now, one thing that I am gathering as I'm watching comments of others throughout the duration of these trials, well, what I'm figuring out myself is that if you've already made up your mind on the first trial regarding this trial, well, you're probably going to judge this trial with that in mind. In other words, if you lean to trust either the prosecution side or the defense side, according to how you felt on the first go-around, you're probably going to give more credence to the prosecution and defense as they present their case during this week. So, let's get into it. Here are some things that happened in week 2. Now, I'm going to share with you in today's podcast what I feel that happened in week 2 that is a major impact on the case. Yep. A major impact, I believe, occurred during week 2. We're going to share that with you. Hang in there. We'll get to that part on today's podcast. Now, I did mention in some of our past podcasts that one of the differences in this trial is that I believe the prosecution will provide better expert witnesses. And I am finding that this is true, but there is a point. I want to point out to you again what I feel, well, this time is another impactful mistake in handling one of the prosecution's key witnesses. You see, in Brennan's opening statements last week, Brennan, of course, is the prosecutor, the special prosecutor that's brought on board for this trial. And if you listened last week, you know that he certainly has credibility. He certainly is one of the best in the nation. He mentioned that he would provide some points during his opening statements. He's going to talk about the battery temperature of John O'Keefe's phone, and that basically he would be relying on cell phone data. All of this coming from John O'Keefe's phone. Well, one of the witnesses that he brought to bring a lot of this information to the jury was a digital intelligence expert. His name was Ian Whiffen, and he was with the company Celebrite. Now, the idea was to explain away the report regarding Apple's way of judging if someone was walking up and down the stairs. You recall the first trial, the defense said that there was some sort of data that would say that he went up and down stairs, and they are alleging that John O'Keefe was not hit by a car, left in the snow to die, but rather he was beaten up in the house, bit by a dog, and then brought out to the yard to die. Now, you probably remember that it was explained away in the first trial about the geographic location. In other words, the elevation would show that the vehicle was going up and down, say in a moving car, and the phone was in your hand. It would show going up and down stairs. Well, in this part of the trial, in the second trial, the direct examination, he was attempting to show that O'Keefe was left out in the snow and that he did not go into the house. However, Whiffen, his own witness, testified that O'Keefe, listen carefully, took 36 steps between 12:31 and 12:32. That would be a total of approximately 34 feet on January the 29th, 2022. Now, a Massachusetts state trooper had already determined that the distance from the flagpole on the front lawn where O'Keefe's body was found, well, the distance from that, well, you're going to look at around 84 feet. Now, here's the clincher. Reed's lawyer, Albert Alessa, he pointed out during the cross-examination of this witness that O'Keefe traveled enough distance, wait for it, to enter the home. And there's more. Whiffen's report indicated the accuracy of the location data declined around 12:36 a.m. That was one of the reasons he listed for the declining accuracy was that the device could have entered, quote unquote, a building or covered area, which he then agreed could have been 34 Fairview Road. And then he ties it up neatly for the jury. He says, therefore, according to your report, the phone of John O'Keefe could be in the house, correct? Then, as you can imagine, there was a long pause. And the expert says, oh, it could be, based on the low accuracy data from that time. But then he came back and said the highest accuracy location shows O'Keefe's phone was outside the entire morning. But there is just that crack of doubt there, is there not? Yep, that it could be in the house. It was a good comeback, but I'm afraid the damage could have already been done. This is the prosecution's own witness saying that he could have been in the house. Now, this next part is where I believe the prosecution made a mistake. You see, Whiffen's testimony actually included a PowerPoint presentation with several slides. Now, we all know, right, that some people learn best with visuals. You got to show it to them. So there was nothing wrong with them having a PowerPoint presentation, but here was the mistake. One of those slides included a map with large circles that showed the radius of O'Keefe's location based on the cell phone data. But now listen to this. That slide was not NOT, not a part of the presentation he showed on the direct examination. But now remember, Alan Jackson is on the other side, and he too is a formidable attorney. He knows his stuff. So you can guess what happened, right? Yep. Up on cross, he shows the slide that the prosecution left out. And then he questioned the expert about it. And under cross-examination, Whiffen agreed that the circles included a substantial portion of the house, which means O'Keefe's phone could have been anywhere within those circles. Hey, that's pretty huge. And by the prosecution not including that in the direct examination, well, it could appear that they were perhaps hiding something from the jury. Juries do not like it when they feel lawyers are trying to hide something. He would have been better off, in my opinion, to have included it and then defended it from the earlier remarks that the highest accuracy shows the phone outside. He could have easily done that, but in fact, that he did not include that slide gave the defense a gotcha moment. If he'd done it the other way, it would not have been perceived that the prosecution was hiding something, you see. So this is a great example of how the prosecution, how actually the prosecution's failure to do that, it turns around and makes the prosecution's expert witness at least an asset for the defense, right? Yep, that's the way I see it. Well, hey, there's more explosive moments in this past week's trial, but now let's just take a moment and share with you what we call Charlie Crimebuster's Crazy Crook of the Week. Well, our crazy crook this week has to do with not a Florida man, but a Florida woman. Yep, here in Florida, we not only have Florida man, we have Florida woman. And here is a crazy crook. And it's very sad because this particular Florida woman wanted to get rid of her 3-year-old son. She was having some kind of relationship with someone else, and I guess the son was getting in the way. Kind of like the prosecution said that happened back in Casey Anthony's situation, right? But this person was really a crazy crook because she decided in order to get rid of her son that she would use a website. A website called, you can't make this up, Rent a Hitman. That's right, Rent a Hitman. Yeah, it's just a made-up phony website just for fun. But its fake customer service awards, the customer testimonials have convinced, get this, more than a few people to submit legitimate requests for an assassin, which has led to at least 30 arrests. That's according to People magazine. Now, the latest to fall for this was this Florida woman, Jasmine Piez, who actually is an 18-year-old woman from Florida. Her request was for a hitman, and this is a little more bone-chilling than most. According to the arrest warrant, Jasmine of Miami sought out an operative to kill her 3-year-old son. NBC News reported that Jasmine submitted an address and photo of the boy and even provided a safe word for the potential killer. The safe word was, put me in, coach. Yep. So this crazy woman who wanted to get rid of her son, but used a trick website to rid a hitman, is indeed Charlie Crimebuster's Crazy Crook of the Week. All right, now back to our main focus. Now, there was something that was said in that very beginning about battery temperature data, and also about that text. Remember, how's loan to die in the code? Well, Brenneman, of course, he urged jurors during his opening statements, he wanted them to really focus in on some data that he was going to present at trial, the GPS, health and battery data from O'Keefe's cell phone. We've already mentioned some of that. Now, that battery data presented at trial this week was new. But how many jurors will really weigh this new information is yet to be found. Because you're going to see there's some problems with it. And of course, Jackson and the defense, they really found those problems and actually jumped on the opportunity again to sow doubt. You see, Whiffen, our expert, had analyzed battery temperature of O'Keefe's phone. He said it dropped 72 degrees at around 12:37 a.m. Now, that would be probably around 6 minutes after they arrived there at 34 Fairview. At least that's what we got from the first trial. At 1:36, he reported that the battery temperature dropped to 50 degrees, and then hours later fell to 43 degrees by 6 a.m., and by 6:14 a.m., the temperature reached 37 degrees. And you put all that together, it means that his cell phone dropped about 35 degrees in 5 hours and 37 minutes. Now, Whiffen told jurors he actually did testing, and he put the iPhone out in a freezer. And I think about that time, the battery dropped about 50 degrees in 15 minutes. And in a second test, he put the cell phone outside, and the temperature was about 34 degrees, and it dropped 31 degrees in less than 15 minutes. Did you hear that? 31 degrees in less than 15 minutes out in the cold. But Alessi, on the defense side, during cross-examination, he pointed out that O'Keefe's phone only dropped 11 degrees in 15 minutes. See the difference? 31 degrees with the test, but yet O'Keefe's phone only dropped 11 degrees. Now, Whiffen, he came back and he defended that testing, said he didn't know what condition O'Keefe's phone was found in, whether it was in a pocket or a case or something else. But testing did prove that ambient temperature would affect the battery. So, I look back at this, and because it did not drop as many degrees as it did in the test, I'm not sure that this is really potent information for the prosecution. I believe, again, there's enough doubt in there to confuse juries. So now let's get to that famous text, the famous text that we talked about. That was a Google search for How's long to die in the cold. When I say How's, H-O-S, which really meant how, that was misspelled. Now, when the Massachusetts State Police used Celebrite for an extraction of McCabe's phone, it actually showed 2:21 timestamp for that text, How's long to die in the cold. That Google search, that was according to Whiffen. But then Whiffen went into a great detail, and he talked about during the examination with Brenham, he explained how the timestamps were recorded on the phone. Said that it was based on when she opened the tab, not when she made the Google search. He also talked about other searches she made about a youth sports team around 2:27 a.m. Now here's another gotcha moment. That text, that infamous text, where the defense says happened at 2:27 a.m. and where the prosecution said, no, it happened later that morning around 6 a.m. You see, if it happened at 2:27 a.m., it means that McCabe had some sort of information that he was lying out there in the snow. And it really would actually boost Karen Reed's own theory about what happened. But if it happened at 6, then that would not go well for Karen Reed. But here's something else. It appears that search shows as deleted. Why did she delete that from the phone? Is that a consciousness of guilt? Whiffen said he didn't have an explanation for how it happened. But he said, quote, unquote, he was confident the search was not detected or deleted by user interaction. Now, I got to ask you a question. How did he know that? How could you be confident that the user didn't do it? If you can't explain how it was deleted, how can you say that the user did not delete it? At least that's what I'm thinking as a juror. Now, under questioning from Alessa, Whiffen did say that Celebrite had updated his software so that the 2:27 a.m. search no longer appears. But he did agree that a separate cell phone extraction tool used by law enforcement still registers the 2:27 a.m. timestamp on McCabe's phone. Well, you can imagine with all this confusion, it was a lengthy testimony, took over 2 days, and I just don't believe that the prosecution landed the blows that they wanted to land with this testimony, with this stringent cross-examination from the defense. So next, there comes a testimony of a witness of whom all of herself Well, it's certainly an explosive testimony. We're talking about, of course, McCabe, Jan McCabe. Now, in his opening statement, Brennan made a point to talk about Reed's own statements, those statements being, I hit him, I hit him, I hit him. And that was central to his case. You could tell that the way he started out his opening. But there was also similar statements. Did I hit him? Did I hit him? So which is it? Did she say I hit him, or did she say did I hit him? Now, the reason Jan McCabe is so important is that she was with Reed and another woman, Carrie Roberts, when they found O'Keefe lying in the snow. Now, I knew, and you knew, if you've been following the first trial, that Jan McCabe would face tough cross-examination. I will say she appeared better prepared during this trial, and she did not appear as combative as in the earlier trial. In fact, Jackson, he even said, hey, did you sit down through a cross-examination, a fake cross-examination to prepare for the trial? Well, she denied that, but you could tell that seems like somebody was talking to her about not being quite so combative, and she did a pretty good job there. So basically, when Jan McCabe came and gave her testimony, Jackson would try to impeach her by showing, and he did, showing inconsistency in her statements. Now, to be sure, she has made a multitude of statements to law enforcement and juries and grand juries, and she can't be expected to remember everything she's ever said about the case. But here's why it's important. Jan McCabe is the sister of Nicole Albert. Nicole Albert is married to Brian Albert. Brian Albert owns the house that the defense is alleging that O'Keefe was beaten up in and bit by the dog and brought out of the snow. So she is a key witness. Now, in a dramatic moment, Jackson handed McCabe a transcript of her testimony to the Norfolk Grand jury, and that was over 200 pages long. And get this was a key question. He said, how many times in this 200-page long testimony did you tell the grand jury about the I hit him statements? She said she didn't know. Jackson comes back because he did know. He said it's because you didn't tell him I hit him. That's pretty explosive stuff. Why didn't she say that to the first jury there? Now, also in the first trial, McCabe testified that she saw Karen's car outside the Canton home all the way up to 12:45 a.m. Now, we know that can't be true because they have proven in the first trial that she was somewhere else at 12:45. She wasn't sitting out there in front of the home, not at 34 Fairview address. But yet in this trial, well, I guess she knew that. Certainly everybody knew that she could not be right in saying that her car was out at 12:45 a.m. So in this trial, she changes her testimony. And that doesn't really always go over good with a new jury. Now, Jackson said not once but 6 times you testified in the first trial that you looked out of the door of the house. Now she's saying, well, I can't remember how many times, but Jackson did get her to admit that she was at that door at least 4 times. And we do know that in the first trial, she did say that she was there to 12:45 a.m. in the morning. It is just inconsistent with her first testimony. And that does not look good for McCabe. Now, the prosecutor does help her out a little bit by the redirect, and he mentions that it's a very hectic time, a lot of things going on. Maybe the jury buys that. Maybe they don't. But there was one more gotcha moment that Jackson used to expose her on the stand. She did not tell investigators. In other words, that morning when she got the call from Carrie about the fact that John wasn't home, she then was asked, who did you talk to before you all got in the car and went and looked for John O'Keefe? She said she talked to a couple of people or somebody else, 2 people. But she did not tell them. She did not tell them that she also tried to reach her own sister's house at the Fairview Road address. Did you get that? She tried to call her own sister's house. Now, nothing wrong with that. I mean, it's her sister. Nothing wrong with the fact that she made the call. Now, it appears that she may not have connected. It was only about 34 seconds or something other. Nothing wrong with that either way, except now it appears that she was hiding it from the investigators. And then you have to ask yourself, why? Why would you hide that from investigators? And that is the point that Jackson is getting across to this jury. Now, another key point brought up in the exchange, McCabe says that Karen told her about the broke taillight. Now, the defense is saying, and showed even a film in the first trial that looked like her car backed up into John's car at the house that morning as they were going to try to find him. So she says, though, that she told her about the taillight way before that time. However, the lead investigator, Proctor, his note says that Jan told him that she was told about the taillight afterwards, which means the car could have backed into John O'Keefe's car that morning, and that was why it was a broken taillight. Also, in the earlier testimony, she said that it was a cracked taillight, not that there was all a group of pieces of the taillight missing. But now she's saying that she said there were pieces missing. But in Proctor's report, it only says a cracked taillight. Then, when questioned on cross-examination whether that morning she heard a collision or any screams for help outside her sister's home, Jennifer McCabe said no. McCabe also said when she left the house, she did not see O'Keefe lying in the yard, which where he should have been if he had been hit by Karen. Now, while Jan McCabe did an incredible job standing up to some of the most grueling cross-examination I've seen in court, there was definitely defense points scored upon cross-examination. Now, before I leave, I told you that I'd reveal to you the most impactful moment of the week. And the crazy thing about that is it happened outside of the jury's presence. But it is an impactful event that will, without a doubt, impact the jury one way or the other. And that is the fact of the ARCA group witnesses. I do think that they had a lot of sway over the first jury. They, of course, said that the wounds and the injury to John O'Keefe was not NOT consistent to being hit by a vehicle. You see, the defense will say that O'Keefe was beaten inside the home, bitten by a dog, and left outside. ARCA, this group of accident reconstruction experts, will testify that his wounds are not consistent to being hit by a vehicle. Now, these guys are among the best experts in the nation when it comes to pedestrians hit by vehicles. So it's no surprise that the prosecution tried to disqualify these key defense witnesses. And this is really it's really unheard of for one main reason. These guys were initially not hired by the defense nor hired by the prosecution. They were hired by the United States Department of Justice to investigate whether Reed's SUV could have hit O'Keefe based on the prosecution's evidence. And that's really uncommon. I don't know that I've ever heard that or seen that. I don't know many people who have ever heard that. And weeks before this trial started, Brennan said in court that the district attorney received notice that federal investigation by the U.S. attorneys had ended. But it doesn't mean that the implications will not end, does it? You see, Brennan had asked the judge to exclude the RK witnesses from testifying because he said the raw data from the investigation they produced was for the federal government and it remained protected by the Justice Department. Therefore, Brennan argued they should not be allowed to testify their findings and that the evidence does not support that Reed's SUV hitting O'Keefe. That evidence that doesn't support it should not be allowed. He went on to say, my position has changed, that these earlier opinions should not come in because they have no ability to cross-examine. He said it was fundamentally unfair. However, Judge Cannon did allow the experts to testify about their original report from 2024 and about a new report that's going to come out, not expected to May the 7th, and that new report will actually be a rebuttal to an expert hired by the prosecutors. This is huge, my friend. I believe that the archive testimony did more to produce reasonable doubt than anything else in the trial. And had those people those witnesses, if they were excluded, and remember, she would not allow Jackson to use any mention of this group in his opening statement until she ruled on whether she was going to allow these guys to testify or not. But then this week, the shoe dropped. And this week, she said while she really thought that they were not following discovery rules and that they had ambushed the prosecution, she said nonetheless, to be fair to the defendant, she would allow their testimony in. And that is huge. That'd be a huge impact. Well, here you go, week 2. Now, we're going to see a repeat of this jury. Will it be another hung jury? Well, those are questions to ponder. I think the prosecution's doing a better job this time around, by far, but will it make a difference? First trial, hung jury. They did not find her guilty. There are a lot of things that can create doubt in this case. The messy blotch investigation by police, suspicious behavior of others. And while, in my opinion, some of that can be explained, yet it could also cause doubt. Yes, sir, there's a lot coming in the weeks ahead. Hey, by the way, do not forget to join us later this week as we discuss this podcast episode. And I kind of give you a mini update of the trial in the 3rd week. You can catch that in the middle of the week. Just go to charliecrimebuster /YouTube, or go to YouTube /CharlieCrimebuster. Put us together, you'll find us there. Until this time next time, this is Charlie Crimebuster reminding you, be safe, be alert, for the life you save may be your very own.
You have been listening to Charlie Crimebuster. We would like to thank our sponsor, the Peacemaker Network, and also encourage you to support the first responders, military, and law enforcement personnel by contributing to the Peacemaker Network. That's peacemakernetwork.com. peacemakernetwork.com. You can also support us by subscribing to our YouTube channel, tag @CharlieCrimebuster. And once you arrive there, click the subscribe button. By doing so, you'll be notified each time we drop one of our shows. Another more convenient way for you to listen to our podcasts are for you to say to your smart speaker, play Charlie Crimebuster. If you have comments or suggestions, we would love to hear from you. So please send them to charliecrimebuster@gmail.com. That's charliecrimebuster@gmail.com. Or you may call or text us at 407-917-2211. That's 407-917-2211. Thank you for joining us today, and we hope that you will join us next week for another exciting crime story with Charlie Crimebuster.